In other news today, Nandipha Magudumana has suffered yet another legal blow. The High Court in Mangaung dismissing her application for leave to appeal an earlier ruling dismissing her bid to have her arrest declared unlawful. She argued that there were compelling circumstances that would see the Supreme Court of Appeal reach a different ruling on her application. She was arrested in Tanzania in April with her alleged lover Thabo, who faked his death in that audacious prison escape. Mnisi reports.
In Dr Nandipha Magudumana's application to have her arrest declared unlawful, the state's version was that she did not resist returning back to South Africa after she was arrested with her alleged lover, convicted rapist and murderer Thabo in Tanzania. The state said she told all and sundry that she wanted to return home to her children. She challenged that in her leave to appeal application, arguing that a person cannot give up a constitutional right by consenting to an unlawful process. But the court ruled that when Magudumana brought her application to have her arrest declared unlawful, she did not ask the court to rule on constitutionality. Therefore, the argument that the court erred when it did not declare the conduct of Home Affairs illegal cannot succeed.
There is also no reasonable prospect of success on the court's failure to declare the 6 respondents' conduct unconstitutional. The facts of the matter simply did not pave the way for such a declarator. The question whether a person can waive a fundamental or constitutional right therefore falls away.
In the judgment that dismissed Magudumana's application to have her arrest declared unlawful, the court found that her return to the country was an extradition disguised as a deportation. It, however, dismissed the application on the basis that she had consented to returning to South Africa from Tanzania. In her leave to appeal application, she further argued that consent would need to be well informed, adding that cases that the court relied on in its ruling were in conflict with each other.
It is simply their version that she wanted to return to South Africa to her children. This was the true nature of her consent, and in my view, the other cases referred to are therefore distinguishable from the present case. Insofar as the applicant contends that the Supreme Court of Appeal should be allowed to consider whether a person may or may not consent to an unlawful and unconstitutional act, I therefore respectfully disagree.
Magudumana was previously slapped with a court order, but in her application for leave to appeal, she argued that there was no basis for such an order as she demonstrated that authorities acted unlawfully when they extradited her without following due process. She also said she was protected by the BioWatch principle that precludes unsuccessful litigants from being awarded cost orders where constitutional issues are implicated.
Having regard to all the submissions made on behalf of the applicant in the present application for leave, I am of the view that those submissions cannot be successful in light of the findings of fact made by this court in the application launched by the applicant. I am therefore not persuaded that another court would come to a different conclusion or that there are other compelling reasons why the matter should proceed on appeal. The following order is therefore made. The application for leave to appeal is dismissed.
It's unclear what her next move will be, but speculation is rife that she could be taking her case to the Constitutional Court. For Newzroom Afrika on Channel 405, I'm Mnisi in Bloemfontein.